Thanks very much to everybody for joining today's virtual boardroom. My name's Jo Thompson and I'm a HR consultant for HR Recruit. Facilitating the boardroom today is Nathan Andrews, and the topic is the disciplinary process, fair outcomes and low risk. So without further ado, I'll hand you over to Nathan.
Thanks, Jo. Hello, everyone. It's nice to meet you, albeit virtually. What I am going to do is share my screen. Jo, could you give me permission?
Oh, sorry.
Thank you.
Yeah.
Right. That's what we need. Okay.
We can't see it at the minute, Nathan.
That's fine. You should. Can you see the front cover with my cursor moving?
No.
Nope. Interesting. Can you see?
Yeah.
Perfect. And my cursor moving on the slide?
Yeah.
Super. Okay. Thank you very much, everyone, for joining me. This is quite a meaty topic, so I'm going to give you a whistle-stop tour, but we will have time for questions afterwards. So if you bear with me, and I will make time at the end to cover for any of your questions. What we're going to cover today is the difference between disciplinary issues and grievances, the ACAS code of practice on discipline and grievance, the difference between disciplinary rules and procedures, the difference between misconduct and gross misconduct, dealing with particular issues, conducting a disciplinary hearing and reaching a decision, and then we'll just cover off the right to be accompanied and the appeal procedure. Now, we're going to cover this off, and it's going to be fairly top level because obviously the time. But as I say, if you have any questions, please feel free to ask at the end. So, if we start with the difference between disciplinary issues and grievances, I know most of you will probably be HR professionals, so this will just be a recap. So, disciplinary issues arise when problems relating to conduct or performance are identified by an employer, so yourselves, and you are looking to address those concerns through your established policies and procedures. Grievances, on the other hand, as we all know, are typically raised by employees who may have concerns or complaints, and these can be related to terms and conditions of employment, working environment, or relationships with colleagues and line managers, etc. Now, when we talk about fair outcomes and low risk, we always advise our clients to follow the ACAS code of practice on discipline and grievance. As I'm sure you all know, both employers and employees should follow this code of practice when handling disciplinary issues. Now, the ACAS code contains 4 sections. You have the foreword, which is purely an advisory section of the code. And then you have an introduction which sets out the general principles which apply to all disciplinary and grievance issues. And then there are 2 further sections which focus on disciplinary and grievance matters as separate entities. Now, I'm just going to move, it gets better. Now, if an employee subsequently brings a successful tribunal claim, as we know, the tribunal does have the discretion to adjust any award up or down by 25% if either party unreasonably fails to comply with any part of the code. Other than the forward, as I said, that's purely advisable. So it's essential when you're handling a disciplinary matter that you do follow the code and that you're able to demonstrate that you have done that in terms of your policies and procedures. So your disciplinary policy, for example, should reflect the key principles of the ACAS code. Now, the code is complemented by a non-statutory ACAS guide. So I kind of treat that as like a how-to guide, and that provides more detailed, practical advice on how to apply a disciplinary policy procedure and the ACAS code together. Excuse me, I've developed a bit of a cough over the last couple of days, so I apologise if I start coughing. Now, in terms of achieving best outcomes, low risk, when handling a disciplinary matter, what I always advise clients to do is to apply best practice. Some people do roll their eyes when I talk about best practice, but actually following best practice principles should ensure that you've acted reasonably and fairly in dealing with your disciplinary matters. And that's ultimately what you want to achieve, is procedural fairness under the general unfair dismissal scheme. So I always say, wherever possible, absolutely apply best practice. Lots of people talk to me about needing to be commercial. And my challenge when we talk about being commercial in these situations is, are you talking about kind of cutting corners or condensing process down to achieve a quicker outcome? Because ultimately that can increase the level of risk involved in a particular employment matter. So disciplinary rules and procedures, I spend a lot of time talking to my clients about these two topics. So disciplinary rules should set out the standards that you require of all your employees, and that includes your management team. So no one should be exempt from your disciplinary rules. They should make clear to employees what is expected of them when they are at work. And they should also set out the consequences of breaking those rules. So I always say it's advisable for disciplinary rules to be contractual terms, so that if an employee does breach those rules, it's essentially a breach of contract. The disciplinary rules should be specific, they should be clear, and they should be fair. And they should also be applicable to your organisation. So it's, I see this often in my work where people have standard policies and procedures, and they don't necessarily apply to the organisation, the type of work they deliver, the working conditions, etc. So it's really important when you're developing a policy on handling disciplinary matters that you make it applicable to your organisation and don't just take an off-the-shelf policy and use it as you've been given it, if that makes sense. In terms of forming disciplinary rules, your policy on disciplinary matters should ideally be formed by yourselves as HR practitioners or business owners, but it's often helpful if you're forming a new policy to do that in conjunction with your staff team, and wherever possible, if it's appropriate to do so, working with your trade union officials and representatives, etc. So some people kind of step back when I say, if you're designing a new policy on handling disciplinary issues, get people involved. They sometimes will make an assumption that we're suggesting that they ask employees permission to write that policy, and that's not what we're suggesting. What we're saying is, if you want your disciplinary policy to be really effective, get people involved when you're forming that, because then you've got their input and you can actually document that actually, when we created this policy, we got people's feedback and input. So it wasn't just the management team doing something in isolation of. That being said, if you've got a pre-existing policy document, that's fine, you leave it as it is and you work with what you have. So just to recap, the rules should be specific, clear and concise, and your disciplinary policy, which contain those rules, should be available for all your staff members, and they should be easily accessible. So I have clients, for example, who are very small organisations. They place copies on their staff notice board, for example. Larger clients have a staff handbook. So wherever you have your policies and procedures, just make sure that they're easily accessible for your team members and that they don't have to ask somebody to access them. They should be freely available. In addition, finally, when you're formulating your disciplinary rules, please make sure that you're really clear on the consequences of staff members breaking those rules, so that there are no surprises. We often deal with that, where staff members in appeals will say that actually they weren't aware of the policy or the procedure or the consequences of breaking rules. So I hope that makes sense. If we cover now the difference between misconduct and gross misconduct, because this is often a topic that we have discussions with clients on. So misconduct is conduct which initially requires disciplinary action other than dismissal. So it's more low level, so it might be a first offence. Gross misconduct is what we would consider to be a deliberate or willful flouting, if you will, of contractual terms, or misconduct serious enough to damage the trust that should exist between employer and employee. So I've just dealt with a gross misconduct case last week, which involved theft, and I dealt with one a couple of weeks ago, which involved assault. So there were very significant issues that did damage the trust that should exist between the employer and employee, and therefore dismissal without notice was appropriate in those cases. So just to give you some examples of misconduct. So typically misconduct would be a minor breach of your company rules and procedures. It might be minor damage to company property, unsatisfactory attendance, unauthorised absence, failure to meet appropriate and expected standards of work, which might be performance management issues, etc. When we talk about gross misconduct, we are talking about, as I said, a deliberate wrongdoing or serious negligence. And what we're talking about essentially is culpability. So culpability is an interesting topic because it can cause problems if you're dealing with a gross misconduct issue that has arisen as a result of a mental health condition, or where it's difficult to prove that culpability was the cause of the gross misconduct matter. So therefore, when we're dealing with gross misconduct, I always say that we should take care and consider all our options and alternatives to dismissal. So dismissal shouldn't necessarily be our automatic go-to, but if you are dealing with a gross misconduct matter and the allegations are founded, then summary dismissal, so dismissal without notice, would be appropriate in the circumstances. So some typical examples for you around gross misconduct would typically be theft or fraud. As I said, I dealt with a case last week around theft, physical violence or bullying, deliberate and serious damage to company property, might be offensive or obscene material, a serious insubordination. So a willful refusal to follow a reasonable instruction would be another example of gross misconduct, unlawful discrimination or harassment. So as you can see, fairly serious matters that you would be dealing with that would ultimately, if founded, breach the mutual trust and confidence that you should have in the working relationship. So in addition to that, you may have matters where there are a series of acts of misconduct which may amount to gross misconduct if they are sufficiently serious enough to undermine trust and confidence. So we often get asked the question, I've got an employee, we've got a series of misconduct issues where in isolation they wouldn't necessarily warrant gross misconduct, but if they're linked and connected, you've managed it properly, it could give rise to you being able to dismiss. So that's just something to think about. Again, in those circumstances, I'd always say, take advice if you're unsure, because each case is typically unique, and it's helpful sometimes to take advice based on all the information. So I'm just giving you a general overview. Okay. So we've covered disciplinary rules and we've covered the difference between gross misconduct and misconduct. So now we want to talk about disciplinary procedures. So disciplinary procedures, they should be created to provide a framework to support your managers. So that's the intention. And they should help your managers deal with disciplinary matters in a fair and consistent manner. So that is the ultimate aim of your disciplinary procedures. Now, just to be clear, disciplinary rules and procedures typically should be included in one document, which is your disciplinary policy, but they are two separate things. So I would always advise that your disciplinary procedures are non-contractual. And the reason for that is that it gives you flexibility on handling issues on a case-by-case basis. So whilst I would recommend your disciplinary rules are contractual and therefore any breach of the rules are a breach of contract, your procedures, so the process you would follow in dealing with a disciplinary situation should be non-contractual, and therefore it safeguards you, because if you find yourself in a situation where a line manager inadvertently doesn't follow the procedures, you avoid having a breach of contract claim from the employee. What I would say is, whilst we say, your procedures should be non-contractual, it allows you to retain flexibility, you shouldn't act in a way that could destroy the trust and confidence between you and your employee. So it doesn't give you the carte blanche to do what you like. You should always be considered in how you manage situations and follow your policies wherever possible. Now, if your disciplinary procedures are contractual, just to make it clear, an employee may be able to argue that the contract has been breached if you deviate from them even slightly. So if they're contractual, make sure you follow your procedure to the letter. That's really important, because what you want to avoid is any claims for breach of contract. Now, in terms of forming disciplinary procedures, I'm sure most of you will have heard of the concept of natural justice. And what we mean when we talk about natural justice is that essentially employees should be informed in advance of any disciplinary hearing of the allegations that are being made against them, together with any supporting evidence that you have that you've gathered as part of your investigation. They should also be subject to an unbiased and impartial decision-making panel, then that's really important. And sometimes a challenge in smaller businesses where you don't have the management infrastructure in place. And if you're working in small business where you don't have a large management team, it may be that you want to outsource the handling of disciplinary matters, particularly if they're a contentious issue. Employees should also be given the opportunity to challenge the allegations that have been made against them and the evidence before you reach any decisions about what you're going to do next. And as we all know, they should also be given the right of appeal against any decisions that you take against them at the end of the disciplinary process. So natural justice, just to explain briefly what I mean by that, it's a technical term in English law. And what it means is it's a rule against bias and right to a fair hearing. So essentially, it is a duty to act fairly. Employers have a duty to act fairly when handling disciplinary matters with their employees. So if you're forming disciplinary procedures, or you're looking to form a set of disciplinary procedures, what we always recommend is that they should be in writing. They should specify to whom they apply. So you want to be really clear that your procedures apply to your employees or workers, and provide for matters to be addressed without undue delay. And that's really important. So it helps manage expectations. Excuse me. It goes without saying, they should be non-discriminatory. They should provide for proceedings and witness statements to be kept confidential. They should indicate the disciplinary actions which may be taken, and they should specify the levels of management who have the authority to take various forms of action in line with your policy. So it should be clearly laid out so everybody understands what will happen if they go through the disciplinary process. Now, again, talking just on natural justice, if you follow I always say this, if you follow the ACAS code and you comply with that, you will automatically be treating your employees fairly. So if in doubt, refer back to the ACAS code and follow that, each step as it's set out, and that will keep you safe and it will keep you compliant. That's really important. If you are working on forming a disciplinary policy, which contains your rules and procedures, and you're unclear or unsure, always take professional advice, because once you form that document and you've introduced it to your workforce, it is something that you will want to comply with. Even if there are some policies where it's completely entirely non-contractual, but I would always say to a client organisation, make sure you follow it, because it keeps you safe and it makes sure that you're treating employees fairly. I'm sure all of you have seen copies of the code, but if you haven't, I'm happy to email you a latest copy from ACAS to Joe, and then Joe, you can share that out perhaps with the notes. Okay, let me move on because I'm just conscious of time. So I just wanted to briefly cover off with you guys, dealing with particular issues. Again, it's a really meaty topic, and if I was running a half-day session, we'd have much more time to get into the nitty-gritty of these, but I'm going to give you an overview, a flavour of how to handle situations, just to keep you compliant and to make sure that you're getting the best outcomes. So if we start with absence, so we always advise our clients to ensure that their employees know who and when to notify when they're absent from work. And that would typically be in your absence policy, or it might be a small section in your employee handbook, depends on the size of your organisation and to what documentation you have. In case of sickness, we always say that the employee should know when self-certification is acceptable and when a doctor's medical certificate is required. So again, we all know this stuff in our heads, but be clear, set it out in either an absence policy or your handbook so your employees are aware. As employers, we should also monitor absence levels, all this good stuff around keeping records that shows lateness and the duration of absences and any reasons for absence. They're really important things that you want to collect and to retain in case you need to address absence levels later on in a more formal way. Now, I just want to talk about absence on medical grounds, and this might typically be like long-term absence. So absence of medical grounds such as injury, disability, long-term illness should be treated as a capability issue, not and not a disciplinary issue. There are other types of absence which may give rise to a disciplinary matter. So, for example, you might have employees taking absence without consent, and if that was an ongoing issue, that could lead to dismissal on the ground of conduct, because that would be a conduct issue. There are other unacceptable kind of levels of attendance which could trigger an absence policy. So if you have a robust absence policy, if you've got an employee that has unacceptable levels of attendance for a variety of different reasons, so it could be that they've taken a day off without authorization, they've got different reasons. It might be cold one day, it might be a family issue the next day. So there have to be different reasons. What that could do is trigger your absence policy and then result in you dismissing them under some other substantial reason. So it would be a conduct issue. So it would be, you would essentially look to dismiss under SOSR. I hope that makes sense. I can give you more information on that at the end. So it's just to break that down. So medical absences should be treated sympathetically and with compassion wherever possible. We always advise that. We also advise that when you are managing issues of medical absences, you should consider things like how soon the employee's health and attendance will improve. That's particularly important in long-term absence cases. Whether you've got suitable alternative work opportunities to provide those employees, what effect their absence will have on the organisation over the long term. So again, this is very much long-term absence issues. Whether there have been any other similar cases within your organisation and how you've handled them. So that's really important. But what I would say is when you're working through absences for medical reasons, make sure that you capture the things you've considered in writing to keep a clear record on file, because if you reach the point where you're going to have to terminate employment because of long-term ill health, you want to be able to draw on the documentation you've gathered over a period of time that can demonstrate you have considered all options open to you and you've not just gone for termination of employment. Okay, excuse me. So unexpected absences should be investigated promptly. So this is typically short-term absences. We see this a lot with clients where they have employees who take frequent periods of unexpected absence. It might be with cold, sickness, again, variety of different reasons. If there are no acceptable reasons for the absence, the matter should be treated as a conduct issue, typically, and dealt with under your disciplinary procedure. But again, in dealing with unexpected absences, just make sure you're keeping clear records. So return to work, so a great opportunity to meet with an employee after a period of absence, to talk about that absence, the reasons why, and to cover off any issues. It's also a good opportunity for you to set out your absence policy and any triggers that you may have in that absence policy that you would then follow to manage any future periods of absence. So again, record keeping is really important when you're dealing with ongoing regular periods of unexpected absence. Excuse me. So I'm not going to go into huge amounts of detail just because of time on criminal charges, but this is something that does crop up from time to time. Oh, have I jumped ahead? Apologies. Poor performance, I'm missing out poor performance. So let me go back. So if we just cover poor performance, so employees are contractually obliged to perform to a satisfactory level. And what I mean by that is they should be able to meet the standards of performance that you expect from them within their job role. So I'm thinking of job description, person specification, where you can set out to the employee what you expect from them in their day job on a day-by-day basis. So that is a contractual obligation for them to perform to the standards that you require. As we all know, setting realistic and measurable standards of performance for all job roles within a business is absolutely essential, and it helps you be really clear with your employees around what is expected. You should also be really clear with employees. Some clients we have, and we do recommend that they have a capability policy, and those do have that capability policy. We also advise them to be really clear with employees when they join the business around what would happen if they don't meet standards of expected performance. So again, everybody's on the same page. Now, performance management can be a tricky topic to deal with, and if you are dealing with poor performance, there are things that we should be considering. Is it conduct or capability? Are there mitigating factors that are contributing to poor performance? So you might want to just sense check that there's no health issues, there's no potential for claims around disability, for example. So when you're managing performance, it's just do your homework, make sure that if there are issues, you're meeting with your employees on a regular basis, you're giving feedback, but you're also asking them for their perspective of why they're not meeting those standards that you expect. Okay, let me go forward. So criminal charges and convictions. Again, this is something we have dealt with a lot actually this year. In the last 6 months, we've dealt with supporting clients with employees who have either been charged with or convicted of criminal activity. What I would say, and again, I'm not going to go into this in any great detail, but just a word of warning, if an employee is charged with a criminal offence, it doesn't necessarily mean that they're guilty. So you shouldn't automatically look to dismiss just because a charge is pending, or if a charge was brought and then dropped. What I would say is, and also we will know that spent convictions will not provide you with proper grounds for dismissal. However, if you have an employee who has been acquitted of a criminal charge, it doesn't mean any subsequent disciplinary action that you take based on that same event would be unlawful. And to put that into context for you, I've dealt with a case recently where we had an employee who was charged with a sexual assault of a colleague, and then that charge was dropped, and the client subsequently took disciplinary action against that individual. They tried to submit claim to the tribunal. However, it was later dropped. But what we did in that situation was, because the employee had entered into what was considered an inappropriate relationship, and that there was reasonable belief to believe that there was inappropriate conduct on the part of this person, their decision to take disciplinary action was unlikely to have been founded in the employment tribunal as being unlawful, because they had carried out a thorough investigation. There was a different burden of proof in employment terms, so it's reasonable belief, which is very different from the burden of proof that the police have to work with, and therefore it was acceptable to take disciplinary action, even though the criminal charge was dropped. I hope that makes sense, but that was just to put that into context for you. Again, we always recommend, if you're dealing with a situation that is involving the police and criminal charges, it is always best to take independent advice to make sure that you keep yourselves compliant and that you don't do anything that could give rise to a potential claim being brought to the employment tribunal. We are nearly there. So just want to cover off conducting a disciplinary hearing. There are no set legal rules to be followed for a disciplinary hearing, and a lot will really depend on the particular merits of the case that you're dealing with. But to avoid any allegation of prejudice, the hearing should be conducted by an independent person, as we all know. So that is someone other than the person who made the complaint against the employee or who was involved in the investigation stage. The person appointed should be impartial, so they should have no personal interest in the outcome. I know in some cases for smaller employers, it can be challenging to achieve impartiality, so therefore outsourcing it to HR consultants, for example, or employment lawyers if they provide an HR consultancy service, can be really useful. And whoever is chosen to deal with the disciplinary matter should have the employer's authority to impose any relevant penalty in line with the disciplinary procedure. So again, that's really important. Now, if you want further information on handling the disciplinary hearing, I'm happy to go into that in more detail, maybe at the end, but I appreciate I don't want to overrun on time. That we're good. Okay, and the decision/outcome of a disciplinary hearing is, unless the case is particularly straightforward, always adjourn. Typically, I say if it's a really straightforward case, you would look to adjourn for maybe 15-20 minutes as a minimum. You want to be able to demonstrate that you've not prejudged the outcome and that you've gone into that hearing, you have presented the evidence and the allegations made against the employee, you've allowed them to respond, you've taken that into consideration, and you've gone away to reflect and digest on their representations. If you're dealing with a complicated matter, we often deal with supporting clients with complex matters. We have adjourned for an hour, sometimes 2 hours before. And then what I typically always do in the period of adjournment is I take notes of what we've discussed and what we've considered. They're not necessarily detailed notes, but they're in a bulleted format. So if later on we were challenged as to how the person chairing that process, so if it was me, I would challenge as to how I reached my decision, I would be able to go back and say, here's the notes from my period of adjournment, and here's what I reviewed and considered before reaching a final conclusion. Reaching adjournment also allows further investigation to be completed if necessary, and also gives you time to consider all of the matters and the representations made to you. So that's really important. The employee should be told about the result of any further investigation if you need to do that. So if you're reaching the conclusion stage of the disciplinary hearing and you need to do some further investigation before you can reach a decision, make sure you tell the employee. There's nothing wrong with adjourning. I've adjourned before for 1 or 2 days if I've needed to go and get further information, but just be clear with the employee so they know when you're going to be able to communicate a decision to them. If the facts are disputed, that the manager conducting the hearing should decide which version is the most probable. It's very common for the employee to have one view and the organisation to have another view based on the evidence they've gathered. What the person hearing or chairing the hearing process, they need to decide which is the most probable version of events. So what is reasonable for us to believe, and you need to be able to demonstrate that. Okay. So briefly, do workers have the right to be accompanied at disciplinary hearings? As we all know, yes, they do. You should offer all employees and workers the right to be accompanied at formal meetings. And when we talk about formal meetings, we're typically talking about meetings where you're going to take some kind of formal action at the end. Investigation meetings, informal meetings where you're not taking any formal action, but you're wanting to maybe have a discussion with an employee. No, they don't have the right to be accompanied. That being said, there's nothing wrong with allowing people to be accompanied if they wish and you feel that's going to aid the proper functioning of a meeting. So, for example, I've recently allowed an employee to be accompanied at an investigation meeting because that's what they needed at that time. So, be considered and be reasonable in all circumstances. And yes, at the end of a disciplinary process, you should always give your employees the right to appeal the outcome. Typically, your disciplinary policy should have a section that covers off the appeal procedure. It should, again, be clear and concise. It should explain to the employee the timeline they have to appeal. Typically, I recommend 5 working days from the date the outcome is communicated to them, and it should ask them to submit their appeal in writing in a clear and concise manner. And then what you would do after receiving an appeal from an employee is to arrange an appeal hearing. Again, give the employee the right to be accompanied and inform them of that right in writing, so you have a record that you've informed them of their statutory rights in all circumstances. Excuse me. And then what you need to decide if you do receive an appeal is whether that appeal needs to be heard as a review. And what I mean by that is starting with the question of whether the original decision that was made was reasonable. So a review would generally be appropriate when there is no new evidence and there's no question of there being any procedural defect in the original process that was followed. You may want to hear an appeal as a rehearing, and in those circumstances, what you would do is approach the matter as if it were the first time. And typically, you would look to do a rehearing if there is new evidence or there was a concern that there was procedural failings in the first procedure that was managed. So that's really important. So typically, when I do appeals, they're normally a review. I have done a couple recently where we've managed on behalf of clients where we've had to do a full rehearing because there were procedural failings, and it was better to adopt that approach because it meant that actually we were safeguarding the business because we dealt with it as if it were the first time. So again, just be considered if you have any concern that there might be, accusations that the procedure was flawed. I would always apply caution and hear the appeal as a rehearing and look at everything with a fresh pair of eyes. There we go. We've done. I can open up to questions. That was a whistle-stop tour. I'm conscious there's lots of content and we're short on time, but I wanted to cover the important elements with you. What I'm going to do, Joe, stop sharing my screen.
And there's a few things that have been posted in the chat box. Are we all right to just quickly go through them?
I've got more than enough time for that. I was just conscious I want to leave time to be able to answer questions.
No problem. If anyone's got any other questions, if they want to put them in the chat box. So somebody's put, the agency worker raised a sexual allegation grievance against the casual worker. The casual worker was suspended on the day. Investigation time, there was not a clear video of the casual worker touching the back body or the agency worker. How do we take this case if I am the disciplinary hearing officer for this? There was no witness.
Well, it sounds like we're talking about you having insufficient evidence, and that can be a challenge. I mean, what I would do is meet with the complainant and take down the nature of their complaint, essentially. So take down as much detail as you can, and then meet with the respondents, the person that the complaint has been made against, and ask for their version of events. Now, I've dealt with lots of issues where there have been insufficient evidence and we didn't have enough grounds for there to be reasonable belief that the complaints had merit, and therefore the outcome was there was insufficient evidence to support the complaint made. That being said, that won't resolve the issue you've got, which is someone's made a complaint that they've been essentially, it sounds like sexual harassment. You were saying, Joe, I can't see the chat. But essentially, what I would do is do the investigation, take as much information from the two people involved, and then look at that information and see whether you have enough to support reasonable belief. It sounds like you're not going to have enough information there.
It says, if there is a case and the investigation is done, can we give the outcome once the investigation is done, or do we have to go through the disciplinary process and then only give the final outcome? Which is the best process? Please advise.
I would, again, I mean, I can give you my thoughts. Don't take this as advice. I would need to know all the specifics, but from what you're saying to me, or the information you're providing, I would suggest that you would absolutely go to a disciplinary hearing. So you would investigate first, and if as a result of your investigation you have there's a case to answer, then you would invite the respondent to a disciplinary hearing to discuss that further. I wouldn't take any decisions or issue any sanctions until you go through disciplinary hearings. I wouldn't do that just off the back of the investigation.
So Caroline's put that she had an issue where somebody spat on a car of his manager where he had a grievance. There's been no physical contact between them both, and she was told it should be considered as gross misconduct. Is that enough?
Yeah, I mean, I would say spitting is that's I mean, if you spat on somebody, that would be considered typically as assault. I mean, I'm not a criminal lawyer, but typically, you would say that was assault. Was the individual in the car at the time?
Caroline, are you able to let us know? Or she's put no.
No, so he's just spat on the manager's car. I mean, I would say that. Another question: how did anyone witness that? I'm assuming they did. Just on CCTV. Look, okay. I mean, there are a number of things I would consider. Would I consider that gross misconduct? I'm not sure is the answer. I think I'd also want to consider things like previous disciplinary record. Spitting is not acceptable. Had he spat at the person or had the person been in the car, I would have said, that's, that could be considered as threatening. I just seen that pop up. I don't have thought Jen was too harsh. I would investigate and want to understand from the individual what was why did they spit on that person's car? What were they trying to achieve? Did they know that they were under surveillance via the CCTV, for example? There's lots of questions I would ask to try and understand motive. But but I'm not sure I would consider that gross misconduct. Misconduct, absolutely, but whether I'd consider that gross misconduct, no, I'm not sure I would.
Caroline's also asked, what's the guidance of the reasonable length for a phased return, 12 to 16 weeks, just to get an idea of when phase stopped and then becomes a permanent adjustment which we need to accommodate?
I think a phased return to work is all dependent on the individual case, really. If you've got somebody on a phased return over a 16-week period, and that's supported by occupational health or the individual's GP or doctor, then absolutely, I would say you follow the guidelines, but you need to be clear on when you want the employee to either return to their job role as it was, or you need to make a decision early on about what reasonable adjustments you can make. What I would suggest, though, is that in those circumstances, if the phased return is for a long period of time, it's just a sense check with either occupational health or the GP why it is for an extended period, because 16 weeks, 4 months, that feels like a long time. But again, it depends on the circumstances and the health matter. Some health conditions can take a number of weeks to fully resolve and to allow the employee to return to their full working duties. So what I would suggest is that, you understand from the GP, if you're uncomfortable with the length of the phased return, why it needs to be that long, and is the employee likely to make a full recovery in their opinion? And then you can start making informed decisions. But ultimately, you should have an idea, I would say now, around what reasonable adjustments you can make, if any. And if you can't, then you need to obviously start just formulating your thinking and your rationale for why you can't accommodate any reasonable adjustments. Does that answer your question? Okay. I'm happy if you've got any, if you pick up with me separately, if you want, you can get my email from Joe if you want to discuss that further.
Someone's put, does the appeal procedure have to be included in the disciplinary policy, or can it be a separate document mentioned in the disciplinary policy?
A good disciplinary policy should have the appeal procedure contained within actually your grievance procedure. So because essentially the appeal procedure, it should be a paragraph about that long, unless you want to set out how you propose to manage the operation of that appeal procedure. But it's very straightforward. So I would always say have it in one, don't have it separate. So that when you're issuing, because typically what you should be doing if you're dealing with a disciplinary matter, invite an individual to a disciplinary hearing and give them a copy of the disciplinary procedure at that stage, so they're aware of the process and procedure that you're going to follow. And so if it's got the appeal procedure in it, then you're automatically ticking all the boxes in terms of compliance and natural justice, etc.
So Joanna's asked, can you please elaborate more on the non-contractual disciplinary policy and more flexibility? What would you put in the contract instead? So
your contract for employment should reference that you have a disciplinary procedure in place, but it should state that your disciplinary procedure is non-contractual. Now, what I was talking about earlier was the difference between rules and procedures. So a good disciplinary policy should have disciplinary rules and disciplinary procedures. Your disciplinary rules are you setting out the expected standards of behaviour that you require from your employees when they're at work. And I always advise that they should be contractual. And therefore, if an employee were to breach your disciplinary rules, it's essentially a breach of contract. That being said, in your disciplinary policy, you should have your disciplinary procedure, which sets out the process you will follow when handling disciplinary matters. And I always advise that that should be non-contractual. And the reason I advise that is that if you have a line manager that inadvertently fails to follow your procedure, what you are not at risk of is that the employee bringing a breach of contract claim, because the disciplinary procedure itself is non-contractual. If your disciplinary policy in its entirety or in part, i.e. the procedure section, is contractual, you must follow it to the letter. Because if you deviate from it in any way, you give the employee the right to bring a claim for breach of contract. So that's what I mean when I say separating out your rules and procedures. When you write your policy, there's nothing more saying this section of our disciplinary policy is contractual. But then when you get to the procedure section of the policy, you make it clear it's non-contractual. Does that answer your question?
Okay, we've got Valeria. She's saying that she's dealing with a dismissal on the grounds of poor performance during a probationary period, i.e. the employee didn't pass it despite extending his probationary period for another 3 months. Were we correct in allowing this person the right to appeal?
I typically advise clients, when you're dealing with employees with less than 2 year service, not to offer a right of appeal, because essentially they haven't got the right to bring a claim for unfair dismissal. So what I typically would do, if you've got an employee that's not performing, absolutely have the probation period, hold probation reviews, and if that individual is not performing, you have the right to extend the probation. But at the end, there is no real need, if you terminate employment in the probation, to offer them the right of appeal. Nothing wrong with doing so, because that is gold standard. It demonstrates you're absolutely being, fair. And if we talk about natural justice again, they're all great things to do. So if you're prepared to go above and beyond, absolutely, there's no harm in doing that. But typically, if I'm dealing with a short, what I would call a short service dismissal, and that's low risk. When I talk about low risk, I'm talking about there not being any exceptional circumstances linked with that issue. So, for example, just making sure that there's no disability, there's no discrimination, potential for discrimination claims based on a protected characteristic, there's no whistleblowing issues, etc., then typically I would terminate and not offer the right of appeal. But as I say, there's nothing wrong with doing so. It just means that if you give them the right of appeal, you have to honour that.
Amanda's asked, how many times would it be reasonable if you need to reschedule a hearing if the employee cancels or doesn't turn up, or the accompanied person can't make that time?
Yeah, so I always allow for 2. I would say, rescheduling once doesn't feel, if someone has to reschedule twice, that could be for genuine reasons. So allowing 2 reschedules is fine. I have before, knowing I'm dealing with a tricky situation, I've allowed a reschedule 3 times, because what I've been doing in that situation is demonstrating reasonableness on the part of the employer. So I would always say, for me, minimum of 2, always allow 2 reschedules. That being said, if the request to reschedule is genuine and you believe that the reasons are genuine, I would say gold standard, go above and beyond. It demonstrates reasonableness from your part, and make sure you document that you've done that, so that if you have any potential claims brought in the employment tribunal, you can demonstrate we've been reasonable, we've followed the process, we've gone above and beyond to support the employee, to assist them in engaging in the process. That would be my advice. Does that answer your question?
Natasha's asked, a colleague was recently dismissed and has since submitted a grievance. Is she still entitled to be accompanied at the grievance hearing, although she's no longer an employee?
Yeah, if you're going to hear the grievance, I would always offer the right to be accompanied. So if you're hearing the grievance, offer her that right. And it could be a work colleague, obviously a former work colleague, or a trade union official. Sometimes when employees have raised grievances after they leave, we get requests for, can I bring a friend? Can I bring I've had friend, family members like husband, wife, brother, sister. I always apply caution. Again, my aim always is, can I accommodate an employee's request wherever possible, while still maintaining the protection of my client, from my perspective, for you guys, your business organisation. So what I would say is, don't automatically, if they request to bring somebody outside of the organisation, don't automatically say no, but just be considered and mindful. I've dealt with situations where, for various reasons, it was case specific, we've allowed a spouse to attend a disciplinary hearing, and actually we ended up having to adjourn and advise the employee or the former employee that, we wouldn't be continuing with their spouse present, because that person became so emotional, so angry, it wasn't conducive to us conducting a fair grievance hearing. So what I would say is, if you're going to hear the grievance, allow them the right to be accompanied. Don't automatically say no if they want to bring someone outside of the organisation, but just sense check. For me, I consider things like other mental health issues. is there a disability where it's of benefit to the individual to bring somebody with them, and if they don't feel comfortable with it being a former colleague, then you might want to make exceptions given the circumstances. But if not, there's nothing wrong saying, look, you're more than welcome to bring a former colleague or trade union representative, because that's all that you're required to do. And the other thing I would say, just on that point as well, I have dealt with a situation before where you've got a former employee who says, well, I can't bring a work colleague because I no longer work for the business, and I wouldn't feel comfortable getting in touch with any of my former colleagues. And so therefore they suggest I'm going to bring a friend, and what's become apparent is the friend's actually their employment lawyer. So just be clear. And in this particular case, I'm talking about the person attending did disclose outside of me, I'm a lawyer, and then what we had to do is say, no, we're not continuing. We were told you were a friend, you know, you can't be here, we're not meeting with you and a lawyer. So just be mindful, if you are allowing somebody in from, you know, to accompany that individual who's not part of your organisation, you need to understand who they are, and just to make sure that you're not kind of walking into a bit of a trap, essentially. Does that answer your question? Perfect. Okay.
I'm just conscious of time, Nathan. There's just a couple more. So Joe's asked, please could you explain the process for the employer? If the police have arrested an employee and have pressed charges, do we go through a disciplinary meeting or should we suspend?
So it really depends on the merits of the case and what the individual has been arrested for. I've just dealt with a really serious matter on behalf of the client involved, allegations of child pornography. And so the individual was arrested, released on bail, pending a police investigation. So what we did is I worked with the client, we recommended that they suspend the individual. We conducted our own investigation, and the outcome was that employee was dismissed. That being said, and we had reasons, there were specific grounds for us making that, you know, the reason to dismiss. So what I would say is, without knowing the particulars of your case, apply caution. Just because someone's been arrested and charged doesn't necessarily mean, as you know, they're automatically guilty. We need to see what happens later on. However, if the allegations that have been made are serious and they have the real potential of bringing the reputation of your business into disrepute, then you're going to want to deal with that, and you're not necessarily obligated to wait for the police to conclude their investigation, because a police investigation could take many, many months, and that's not something you're necessarily going to want to sit on. So what I would say is get advice on your particular case, and make sure that whatever action you take is reasonable and fair in the circumstances. But you aren't obligated to wait for a police investigation to conclude before you take action. So that's the headline. But I wouldn't want to give you any further advice without knowing more of the details. So I hope that helps.
Are you okay for one last one, Nathan?
Yeah.
Okay, so Angel has asked, an employee raised a complaint about a manager, and then I think it's the manager, and then they've gone off sick. Oh, sorry, the employee. Employee's raised a complaint about the manager and then has gone off sick. Sorry, let's click that. Do we still go through with the investigation or wait until they return?
Well, you could, there's nothing stopping you from concluding your investigation, but if you need to speak to the employee and they're off sick, then what I would say is that you would hold fire until the employee returns. The only challenge with that is, obviously, if the employee is signed off, I mean, I'm making an assumption they're signed off, they may be self-certifying, so they can only do that for some days. So if they were medically certificated, and say it's for a month, and you think that's going to be an ongoing issue, you may not want to hold off on conducting the investigation as far as you can, because, if you've got to meet with other employees and take witness statements, you don't want memories to fade. That being said, if they made a complaint against the line manager, we're looking at a grievance situation. So you need to make a decision in those circumstances as to whether you can manage the disciplinary matter and the grievance concurrently, or whether you need to put on hold the disciplinary matter and investigate the grievance before you proceed with your disciplinary proceedings. So I hope that helps. Okay,
so I'm going to end the session if that's all right with you, Nathan. Is there anything else that you would like to add?
No, just thank you very much. I kind of rattle through it because there was lots of information. I hope it wasn't too much information overload. If it was, I apologise. And if you have any questions and you want to get in touch, you can find me on LinkedIn. I'm happy if you want to share my email, Jo. So if you've got any questions, go to Jo first and she'll give you my email address. But yeah, it's super lovely to meet you all, and thank you for listening to me waffle on for an hour.
Thanks very much, Nathan, and thanks very much to everybody for joining. I will put a post on LinkedIn as usual. If anybody wants a copy of the presentation or the event, wants to listen to the event, then please put a post against the LinkedIn message. We've got another event next Thursday. It's actually in the morning, which is a mock investigation, and it's being run by Vista Employer Services. So there will be a link on there if anyone wants to sign up. If anyone is recruiting for HR people, then please contact me. We've also got accountancy recruit and finance director recruit in the group as well, if anybody has got recruiting for those positions. Otherwise, I'd just like to say thanks very much. Thanks very much to Nathan, and I hope that you enjoyed the event.